Okay, it's recording now.
Mm-hmm.
I don't know what it's recording. Let's go in here. Yeah, Court of Appeal. This is a civil appeal. So they have been going through all kind of courts and tribunals up with the FCA, where they're saying I'm trespassing and uh, being evicted. They have court orders. They're publishing all the papers. So they come back to me and said they made a decision on the papers, and I've got no right to do anything. I'm dead. They told somebody the case is dead when we went to file paper. So I said, well, at the very least, I need to see the orders on which the decision is based. That's what I've been asking for 3 years. For at least 10,000 times I've asked different people. So I said to them, this is my final notice before action criminal. That's where it comes to. Andrew Bailey has been copied in by way of service. Yeah.
Mm-hmm.
So you stated, and I quote, this is what the court told me. I refer to your email dated 8th of December.
Mm-hmm.
So I sent them a final notice before criminal action. So
Mm-hmm.
they say it's an email. The position remains as stated in my email of 2nd of November 2017. There is no right to further review or reconsideration of the order of Floyd L.J. Lord Justice, dated 16th of October 2017. So there is no right. So somebody is removing my right.
Right.
um, you further stated, and I quote, this is my email to them, yeah?
Mm-hmm.
In reference to Mr. Badaloo's request for a stamp copy as per CPR. So I said, I'll file a document. Can you give me a stamp copy back, please?
Yeah.
This is a master here. Master whatever bankrupt, yeah?
Mm-hmm.
Bankrupt Rima or something. Interesting name. I assume, the master is assuming, yeah?
Yeah.
That he is requesting the final notice on action before action criminal. Now they're calling it the proper name. Yeah?
Right.
To be sealed. See how they're twisting the language here.
Mm-hmm.
I'm asking it to be sealed.
All right.
They're supposed to stamp every court document filed.
Of
Stamp the
course.
one you file and stamp your copy. This is the civil procedure rule and common sense, common law.
Mm.
How else will you know you filed it?
Good correct.
Sealed by the court. There is no provision in the CPR which obliges the court to do this. This is not the request that Mr. Badaloo is making. And he is asked to clarify what he's asking the court to do. So they open the door, they ask me to clarify something.
At least they're
Huh?
asked to clear. Yeah,
Do you
huh?
want to push the door up for me?
Push it.
I'm talking loud and makes people...
Oh, I see.
Yeah, so anyway, let's whiz through this.
Mm-hmm.
So this is my... so this is the other scam. There is no right to a further review or reconsideration. I didn't ask for that. The second time they're telling me that. I didn't ask for a review or a reconsideration.
Yeah.
Yeah?
I got
I
it.
asked them to give me the orders on which the decision was based.
Yeah, that's right.
Yeah?
Yeah, yeah.
So they're answering a question I didn't ask.
You could
And they're doing
right.
it. So this is my response. Take notice. I believe that both the judiciary and the administration is fully aware without the need to assume on the difference between a court stamp and a court seal, and that my request is very clear that I wanted a stamped copy of my filing. So
Yeah.
I'll answer that one.
Right.
Please accept my apologies due to scanning error. Page 2 of my document, final notice before action criminal was missed out. I hereby attach the complete document and attachment again for your kind and most urgent attention.
Mm-hmm.
I'm polite.
Yeah, you're perfect.
Always use the word kind. I know,
Yeah,
you know, it's a
yeah.
good thing. No matter how bad the thug is, be kind to the thugs. So I attach here a void order. This is a quote from Lord Benning. A void order results from a fundamental defect in proceedings. Upjohn L.J. in re Pritchard, deceased 1963. Blah blah blah. Yeah, some court cases here. You make an order based on rubbish. It's nothing. Not worth the paper. That's what it's like, a fake £10 note. Fake £50 more. It says same exact thing.
Yeah.
Request. Please clarify as to how the court came to the conclusion for the second time in succession that I made a request for a further review or reconsideration, when it is more than clear that I am asserting my right under the Access to Justice Act 1999, Section 54, brackets 2, to an appeal trial. It's a right to an automatic right.
Go ahead.
The court doesn't have any discretion on it because they're accusing me of trespass.
That's a good one. That's a good one.
Yeah?
Yeah, I like
Please confirm if it is the rule of the court and my entitlement to have documents filed duly stamped by the court. So let's clear that up now.
Yeah.
Because you're going on about it. That's bullshit. Kindly attend to the matter with page 2 attached, along with a copy of the Access to Justice Act. This is about the 5th time I'm attaching this, yeah?
Yeah.
Affirming my absolute right to a trial, appeal, and proving that the court has no jurisdiction, to deprive me, making the order of the 16th of the 10th, 2017 is void.
Right.
Because they don't have any jurisdiction to make an order without the information which they're making it on. Provide me by return with a stamped copy of my document, final notice before action criminal. Please confirm that a trial date is being arranged for my appeal, as there is no other lawful course in these proceedings unless the FCA conceded that neither Andrew Bailey, CEO, nor any of the gang members are in possession of the order for possession nor the order of conviction on which these phantom proceedings have been artificially grafted to engage in bullying, discrimination, and hate crime. How is that?
That is powerful.
But that's what it is.
That's going to be powerful.
Many thanks. CC, to whom it may concern.
Yes.
And I attach my final notice and before criminal action.
Leave it like
No,
that.
let's go through this. Let's go through this.
Complicated, and this is going to shake the system up.
Let's go through this. What am I doing here? Let's open that one up by itself. Where is it? Magic of technology. So how do we get rid of this one? So, bam. There we go. A little bit bigger. So address it to the court manager, Johanna Ahmed. She's the lady who told me on the phone, and I recorded it. She has never seen a sealed order in 10 years of working in the Court of Appeal. I got it on video. You can never make it up.
Oh my. Yeah.
Never seen. That means she never seen mine either.
Yeah, correct.
Final notice before action, criminal, blah, 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 and versus Andrew Bailey, because he's responsible for all the staff and agents at the FCA.
Yeah.
And this phantom case here, Mrs. Ahmed, new action by the FCA reiterates that Andrew Bailey and the FCA staff have been provided with untrue allegation that the county court at Barnet has issued possession proceedings against me and my family members. Not just me, so many people. As it appears, there is a small group of individuals passing around the above rumor to each other over the last 3 years, fully in the know that amongst the entire gang, not a single member has in their possession any authentic instrument issued by the court. Issued by the court. They might have some bullshit stuff, but it's not issued by the court where they made it. But they still don't even have a bogus one. It's got blank. And this is the Court of Appeal, upper tribunal. It's a disgrace on the Queen. Namely, an order for possession, a warrant, an order of conviction in compliance with the County Court Act 1984, Section 134, which says basically all court must be a court of record and must have a seal. In other words, court documents must be sealed, otherwise it's not court document. You make up a document, it's not a court document until it's got the blessing of the Queen,
Okay.
which you claim to be using against myself, my family, and my community. The persistent and unrelenting assault on my liberty, my human rights, and my livelihood demonstrate that there is a clear and unfettered intention to cause me harm and loss through bullying based on discrimination only. Because there is no evidence of anything.
Yes.
The repeated publication in the worldwide visible medium and press of criminal conviction for trespass and theft in my own matrimonial home, when none of the gang members have produced a single shred of evidence of valid possession proceedings and a warrant, nor an authentic order of conviction, is clear proof of an intention to tarnish my good reputation in pursuit of hate crime. At all times, each gang member is relying on emails, hearsay, and undisclosed allegations as a poor excuse to justify the human rights violation. So it's signed here and sealed with a thumb seal, and they don't seal anything, so when you seal something, it scares them a little bit if they're wrongdoers.
That's correct.
If you make your document authentic, they must make theirs authentic as well. Take notice, I have never been served with any possession proceedings duly paid for and issued by the county court at Barnet nor any other court. I have never been served with any order of conviction issued by the court which could affirm that I am a trespasser in my matrimonial home, from where I and my family members have never been evicted. So according to the Protection from Eviction and Harassment Act, Section 1, 1977, we've been deprived of our home. We've been unlawfully removed by thugs. So that's not an eviction. That's a criminal raid. The order made on by the Court of Appeal the 16th of October is void for the reason that the adjudicator did not have in his or her possession the order for possession nor the order of conviction upon which the proceedings have been artificially drafted. Because that's the foundation. There is no foundation, there is no case. Request, provide by return a copy of the claim for possession issued by the court and served on me in case number 3BT T01335, Finework Benson, Channel Islands Limited versus Anthony Badaloo. A copy of the receipt for the court's fees paid to enable the proceedings to be issued by the court. So according to the rule, you don't pay the fee, the court can't do anything. It can't take another step. The first step is the fee. Apart from the fraud and tax evasion and all that, it's a physical impossibility to have a case where the fee hasn't been paid. And the Ministry of Justice has confirmed it in black and white. So anyway, number 3, a copy of the warrant. You can't be removed from a house without a warrant. Duly paid for, because you have to pay a fee for the warrant as well. It's a separate thing. And issued by the court, on which my family members and I have been lawfully evicted and had our belongings stolen. A copy of the authentic court order issued by the court to justify the allegation of trespass in my matrimonial home on the 1st of April 2015. Now, that day I'm the owner at the land registry. I asked the FCA, there's a guy called Roger Hilton, solicitor, registered with the SRA, to give me the land registry to establish what is what here. He gave me the land registry for 2016. So I supplied him one with this date, showing my name on the title. And he goes to me in writing, we won't use that one. We're not using that one.
What?
So he's using one that doesn't apply on the date. It's unbelievable.
Oh, pickles, man.
I require my trial appeal, and I am not out of time as this is a criminal causal matter. Trespass and theft is criminal, would you say? Theft is criminal. They want to say everything is a civil matter. People come and break your door, it's a civil matter. being allegations of trespass and theft. I am awaiting the trial in compliance with the Criminal Law Act 1999, Section 54, subsection 2 attached. The court does not have any jurisdiction to refuse my trial appeal under any circumstances whatsoever. Simple. Take notice. In case you fail to comply with my request 1 to 5 to produce the missing documents and instruments. Yeah? A document is a document when it bears the seal of the court and is properly and authentically done. It becomes an instrument on which action can be taken. If you don't have an instrument, you have nothing.
You have nothing.
Yeah.
Yeah.
On which the void order of the Court of Appeal was based to deny my right to a fair trial and access to justice, or in the alternative, restore my Part 4 permission by close of business on the 15th of December 2017, or action will be taken against each individual malfeasor who will be held accountable for aggravated damages in addition to all other charges, criminal. So each malfeasor is established in case law. If 10 people do you wrong, each 10 of them has to pay you out. Pay their own damages. So you could get 10 times the damages. It's irrelevant. Each wrongdoer has to pay his own penalty.
Right.
That's the law. The repeated silent treatment and denial of my right to an automatic appeal trial amounts to bullying, discrimination, and hate crime. Implied admission by the absence of a response, this notice will be used in evidence. I gave them a beautiful signature there and a seal, and I attached some stuff where people saying they're taking action or whatever. Blah blah blah. And this is where it says they're published in the newspapers, lots of papers, but I just picked this one. And it says here, I was convicted in the Harrow Crown Court, yeah? And I was sentenced for community order. Where is the order?
Where is the order? Nobody knows where this bloody order are.
Unpaid work of 100 hours and was ordered to pay 3,500 in costs plus a £60 surcharge. So on these orders now, there's a London Collection and Compliance, which is part of HMRC. They've been pursuing me 3 years now for this money. And I offer them to pay them. I said, here you can have the money. I got it.
Order.
I want to see the order.
I want to see the order, correct.
So they've handed it to one bailiff. I said the same thing to the bailiff. Another bailiff, he came to my house. I offered him to pay. I want to see the order. I videoed this. I'm going to put it out soon.
Yeah.
He ran away. I never see a bailiff run from money before in my life.
Oh my.
Give me your ticket and you take your money.
You take the
no
money.
Ticket, no money. I'm sorry.
Yeah.
Now, the community order or unpaid work, I asked them for the order. And they said they couldn't produce the order, so I said, well, I don't want to go on a community service. There's no order. And so I didn't go, and they took me back to court for breaching the order.
Yeah. Oh my God.
And I went to see in front of Judge Greenwood, who was trying to lock me up for 3.5 years based on breaching the order. I asked Judge Greenwood 50 times, can I see the order, Your Honor, so I can make sure I comply with its terms?
That's right.
And every time he doesn't give a straight answer, at the end of the trial he says, blah, 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 I can't give you an order, you can stand till you die. This is what the judge said.
Really?
Because I want a sealed order.
Oh Oh
Yeah?
my God. Oh my
Yeah,
God.
this is Judge Greenwood, who is now mysteriously disappeared, by the way, like lots of people in the case.
Yeah.
So they said here the FCA attempted in February, when is it? In February, attempted to cancel Mr. Badaloo's petition, but I took it to the upper tribunal. So, did the FCA give the upper tribunal the order? No. So how can the upper tribunal make a decision? Roger Berner says, I make no finding of facts. Judge Roger Berner.
Yeah.
But then somehow this decision, which is not a court order, is against me.
Yep.
But it's no fact, so what is it? It's a fiction. Okay. Ghosts and phantoms. So the newspaper twist is a fake newspaper, yeah? I've asked the newspaper many times, this paper and the journalists, can they kindly write to the court and obtain the order before they publish anything?
Yeah.
So at some point, these guys are going to pay me a bit of money.
Of course.
Which I got no complaints about.
Absolutely. They all will.
They said, Mr. Badaloo, the tribunal ruled that hearing the case would constitute an abuse of process, but they heard the case. There was 12 of us there. Because it would allow Mr. Badaloo to argue that his conviction has either not occurred or been wrongly convicted or sentenced. Where is the conviction? You see how they trick you on words here? Where is it?
Yeah, where is it?
Has anyone seen it?
Oh my God, man.
So let's go down here. This is the Access to Justice 1999, Permission to Appeal, Part 4, whatever. Rules of the court provide a right of appeal to High Court, blah blah blah, may be exercised only with permission. Yeah? This section does not apply to a right of appeal in a criminal cause or matter. So I don't need anybody's permission.
Yeah, correct.
It's automatic, because they're accusing me of trespass and theft.
Correct.
And I can't lose.
Yeah.
This is the Law Society Gazette about a solicitor. I just attach it as supporting evidence. Solicitor fabricated litigation for 3 years. This is exactly what is happening to me.
Wow, right.
Yeah?
Right.
Sweet,
That's
isn't
a
it?
good one.
It's a good find. 3 years. And look, fictitious court hearings and judgments, made up conversations with other firms in a 3-year deception.
My God, man.
Blah, 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 blah. False document technique was so extraordinary, it could have come from one of A.P. Herbert's misleading cases. Book, apparently. So this is a fantastic one. Include Hamblin's judgment says the false litigation involved fictitious hearings before the commercial court and the Court of Appeal. We're in the Court of Appeal now.
Right.
Purported judgments.
Oh, yeah.
Okay, look at this one. Purported sealed court orders. Purported transcripts. Purported skeleton argument, purported correspondence with court officials and claimant solicitors. If I said this, but this is in the Law Gazette for the Law Society.
Oh, yeah?
Rock and roll. Don't start spending the money. Slow down.
And I'm already,
Slow down.
already sticking here.
Service your vulva. Service your vulva for the time being. So anyway, impersonating of senior partner and leading counsel. Yeah? Throughout the whole period, there was no contact with Norton Rose or the court. So it was made it outside the court. It was never issued by the court.
Never.
That's why we use the word issued by the court.
They're
making it up in their little basements.
That's right.
Where they mess with kids as well, I heard. Good authority.
My God.
The police and the solicitors regulate. Ha ha ha! It's gonna be a civil matter. I can feel it coming. Yeah. So, bang. That's that.
Wow. Man, he's gonna have some fun from now on, I'm telling you.
How do you switch this thing off now? It's a whole show to switch it